We libertarians here at Cato, we have sort of a unique perspective on public policy. As you probably know, we're liberal on many of the social and civil liberties and foreign policy issues, but conservative on domestic economic, fiscal, and regulatory questions. Conservatives and libertarians are generally allied in a pretty vigorous effort to limit government power, but there is a corollary, let's call it a flip side to government power, and that is individual liberty. And on that score, conservatives and libertarians will occasionally disagree. And today's discussion of same-sex marriage is a prime example of that disagreement. So why is it that libertarians argue that there ought to be a right to same-sex marriage? Thomas Jefferson set the stage in the Declaration, where he wrote, "To secure these rights, governments are instituted among men." So the purpose of government is to secure individual rights, and that means that we must prevent some persons from harming other persons. So here is the threshold question. Whose rights are being violated and must therefore be secured by government action when two gay people get married? And the answer, of course, is nobody's rights have been violated and nobody is harmed by the union of two consenting gay people. And even if it could be shown, and here the evidence goes the other way, even if it could be shown that heterosexual marriages are vital for child rearing, that fact would have constitutional significance only if you could also show that allowing gay marriages somehow precludes or reduces the number of heterosexual marriages. The key question, and it was raised by David Boies in his remarks, is why is it that government should be involved at all in the marriage business? It should not. For most of Western history, marriage was a matter of private contract between the betrothed parties. Marriage today could very well follow that tradition. It should be a private arrangement requiring minimal or no government intervention. Some religious or secular institutions would recognize gay marriages. Others would not. Still others would call them domestic partnerships. Join whichever group you wish to join. No one would have to join any group, and no group would have to adopt a definition that members of the group found to be offensive. The rights and the responsibilities of the partners would be governed by personally tailored contracts, consensual bargains like those that control most of the interactions among people in a free society. Government benefits, to the extent that they are dispensed and to the extent that obligations are imposed by government, that could be just as easily triggered by other objective criteria, leaving the definition of marriage in the hands of private institutions. The qualifying criterion might be, for example, an affidavit identifying the partner, certifying that the partnership is intended to be exclusive and permanent within a common residence with shared responsibilities. It's not necessary to key benefits to marriage, and in fact, 60% of Fortune 500 companies now extend benefits to domestic partners. Now, that's the ideal. Regrettably, however, government has interceded, enacting more than 1,000 federal laws and who knows how many state laws dealing with issues like taxes and child custody and inheritance. And whenever government imposes obligations or dispenses benefits, the Constitution is implicated. And the Equal Protection Clause of the 14th Amendment says that no state may deny to any person within its jurisdiction the equal protection of the laws. That provision, of course, is the relevant constitutional issue when it comes to same-sex marriage. And I must say that that is where conservatives and libertarians sometimes part company. And I want to explore that parting of company by looking at two particular topics. One is federalism, and the other is this issue of fundamental rights. First, with respect to federalism, why don't we simply leave same-sex marriage question up to each state? You may know that from the get-go, at the time of the framing, the Constitution only applied to the federal government. The First Amendment, for example, says Congress shall make no law. It says nothing about the states. We learned over 80 years that the states can be every bit as tyrannical as the feds, slavery being the case in point, and so we fought a civil war. We passed some post-Civil War amendments, including the 14th. And the 14th Amendment effectively makes the Bill of Rights and other provisions in the Constitution applicable against the states. For the first time, the federal government could intervene if the states violated constitutionally secured rights. And that significantly altered the balance between state and federal governments. Although the states have broad discretion in fashioning rules for same-sex marriage, the U.S. Constitution sets the outer limit. So federalism, for example, surely allows some states to recognize same-sex marriages while other states opt to privatize all marriages, and still others call all marriages domestic partnerships. But the states may not discriminate as between same-sex and opposite-sex unions without justification, and none has been shown. If the states discriminate by recognizing heterosexual but not homosexual marriages, federalism does not excuse compliance with the Equal Protection Clause, and that is the crucial change to federalism rooted in ratification of the 14th Amendment. And I think somewhat hypocritically, the same conservatives who invoke federalism to argue for Proposition 8 proposed in May of 2003 the Federal Marriage Amendment, which defines marriage throughout the country as the union of a man and a woman. That amendment prohibits states from recognizing same-sex marriages within their own borders, even if desired by the state's citizens. And it also bars the legal incidence of marriage, such as civil unions and domestic partnership. That regime would be fundamentally at odds with principles of federalism. Next, consider this issue of fundamental rights that, again, both David and Ted mentioned. Since the New Deal, the courts have rigorously reviewed government regulations only if they infringe on a fundamental right. And to qualify as fundamental, a right either has to be implicit in the concept of ordered liberty or deeply rooted in our nation's traditions and culture. And how that right is defined, narrowly or broadly, makes all the difference and can even dictate the outcome of the case. Some conservatives argue that the right to same-sex marriage doesn't meet the criteria for a fundamental right, and therefore the courts should defer to the legislature. Well, I'd like to talk about two cases that address this question. The first case is Raich v. Gonzalez. A sick person claimed a fundamental right to use medical marijuana in California, where the use of such narcotic is legal, and she had, in fact, a doctor's order. The Court of Appeals characterized the right as the use of narcotics for medical purposes. So Mrs. Raich lost because medical marijuana, said the court, is not indeed required for ordered liberty, nor is it deeply rooted in our nation's traditions and culture. Suppose the court had adopted Ms. Raich's characterization of the right, and that is the liberty to pursue a less painful life without infringing on the rights of anyone else. She would have won that case. And for a contrary example, consider the case of Lawrence v. Texas, in which the Supreme Court overturned a Texas law that criminalized consensual homosexual sodomy. Texas lost that case. Why? Because the court characterized this relationship between two men as being within the liberty of persons to choose. Suppose the court had said that this right is simply about the right to practice gay sex. The right would not have been deemed fundamental. Which characterization is correct? The nasty little secret of constitutional law is that, in part, both of them are correct. Raich was indeed trying to live with less pain, and she was also using medical marijuana. Lawrence was pursuing a private, consensual relationship. He was also engaged in gay sex. And similarly, Chris Perry's right in Perry v. Schwarzenegger could be characterized narrowly as marrying another woman, which might not be considered deeply rooted in our traditions, or it could be characterized as Ted and David and ultimately Judge Walker did, as choosing a spouse and forming a household, which would be deeply rooted. So sometimes courts can rule based on how it is that they describe the right. And that is, in the libertarian view, the foolishness of bifurcating our rights into fundamental and non-fundamental categories. All rights, enumerated, unenumerated, fundamental, non-fundamental, should be rigorously protected by the courts, and that is the view of most libertarians. Too often, it is not the view of many conservatives. So from liberals, with all due respect to Mr. Podesta, we sometimes get too much government, an enlargement of state power. And from conservatives, with all due respect to Ted Olson, we sometimes get too few freedoms, protection of some, but not all, of our constitutionally secured rights. The left and the right are selectively indignant about the proper role of government. That reflects, I think, an inconsistency among both liberals and conservatives on their views of rights and powers. Libertarians, by contrast, have a consistent, I'd call it minimalist view of the proper role of government. We want government out of our wallets and out of our bedrooms. Libertarians view the powers of government very narrowly, the rights of individuals very broadly, and that, of course, was precisely the vision of the framers. Thanks very much.